Friday started like any other morning in Miami, except it didn't. At 6:47 a.m., 4 US Marshals arrived at Ivanka Trump's Star Island residence. They weren't there to knock politely or ask questions. They were there with a court order, ready to seize her passport, enforce compliance, and set a series of events in motion that would ripple across her personal, business, and family life. By the time they left, the Marshals had not only taken her travel documents, but also cemented a series of actions that make clear this is not a typical legal maneuver. $127 million, 23 shell companies, 2 years of investigation, and a single 2-hour testimony behind closed doors had converged into what court filings now suggest is one of the most comprehensive financial probes involving a former White House official in recent history. Headlines gave you the surface-level story. Court documents give you the skeleton, the pulse, and the human drama beneath it all. The documents, all 187 pages, lay out a timeline, a map of financial movements, and a glimpse into the family dynamics that are just as pivotal as the money itself. Melania Trump, stepmother to Ivanka, had already stepped into a federal building in Washington the day before. She spent 2 hours under oath, answering 147 questions, taking only a single break and declining to invoke the fifth. That testimony would pivot the trajectory of the investigation entirely, transforming what had been a paper trail of numbers and transactions into a human story with motives, awareness, and intent. Federal prosecutors had the records, sure, but they now had context. The core of the investigation revolves around the Trump Organization and its complex web of business entities. Ivanka Trump, former senior advisor to the president, manages dozens of LLCs across 6 states. According to court filings, the transactions through these entities constitute what federal investigators believe is money laundering. They allege a deliberate structuring of transfers to avoid reporting thresholds and a movement of funds through companies that exist solely on paper, with no employees, offices, or apparent revenue. This is not conjecture, it is documented in exhibits, wire transfer authorizations, and bank records. Between March 2023 and November 2024, Ivanka's signature appears on 31 separate wire transfers totaling $84.7 million, routed to a Cyprus holding company, a Cayman Islands subsidiary, and a Nevada LLC, all without legitimate operations. What's more, the filings indicate repeated withdrawals of cash just under the $10,000 federal reporting threshold. Over 14 months, Ivanka personally withdrew $3.2 million, never more than $9,500 at a time. Investigators flag this as structuring, a legal term indicating intent to bypass financial reporting requirements. And the documents reveal Melania's testimony confirmed the pattern. She recalled Ivanka discussing how to keep transactions under reporting thresholds. Prosecutors argue this was not ignorance but knowledge. Ivanka's role in the administration allegedly gave her specialized insight into federal financial reporting requirements, which turns each transaction from a simple business movement into potential evidence of deliberate evasion. The unfolding of these events was fast and deliberate. The grand jury in Manhattan had been convened months prior. Subpoenas went out, and Ivanka's legal team fought them vigorously. Motions to quash were rejected. But the game changed when Melania cooperated. Her testimony brought human context to the financial evidence. This combination of paper and testimony prompted the immediate action by US Marshals at her Miami residence. The sequence is telling. Testimony on Thursday. Passport seizure Friday morning. Bond set at $15 million Friday afternoon. GPS monitoring installed. And devices ordered surrendered all within a single day. Federal prosecutors were methodical. They weren't improvising. They had a plan, and they executed it with precision, indicating confidence in the evidence. The seizure of the passport and the imposition of a $15 million bond tells you volumes about the court's perspective. Judges do not lightly grant such measures. The risk of flight must be real, documented, and immediate. Ivanka's international business dealings and access to private aviation made her a prime candidate for heightened restrictions. The bond, GPS monitoring, and surrender of travel documents were designed to neutralize that risk, ensuring she remained within the Southern District of New York while the investigation progressed. And yet, there's more beneath the surface than just the financial numbers. Melania's testimony itself is unprecedented in federal prosecutions. Stepchildren rarely cooperate in cases involving other family members, and the weight of that testimony is significant. It humanizes the otherwise abstract numbers and creates a direct line between intent, knowledge, and action. Legal experts stress this point repeatedly. Family witnesses are rare, and when they testify, they are extraordinarily influential, especially when paired with extensive documentary evidence. The financial evidence alone is substantial. The indictment outlines wire transfers moving millions to entities with no operational presence, structured withdrawals just under reporting thresholds, and a pattern that spans nearly 2 years. Exhibit F, buried deep within the filings, shows a systematic pattern of withdrawals never exceeding $9,500. Exhibit G includes 67 pages of emails, texts, and voice transcriptions, all part of the mosaic the prosecution is assembling. Every transaction, every note, every internal communication could corroborate or contradict the testimony, and that's why federal authorities have now ordered Ivanka's devices surrendered. Laptops, phones, cloud storage, everything used for business communications since 2021. Investigators want to cross-reference the human testimony with the documentary record. If deleted messages exist, forensics will find them. If encrypted apps were used, they will map the pattern. The stakes are high, and the timeline is compressed. From a legal strategy standpoint, both sides are aggressively maneuvering. The prosecution asserts a clear pattern of knowledge and intent, while the defense frames the activity as legitimate business operations, international licensing deals, and brand management contracts. The defense also challenges Melania's credibility, highlighting potential personal and financial incentives for her cooperation. This clash of interpretations underscores the difficulty of the case. Structuring cases require proof of intent, not just evidence that transactions fell below reporting thresholds. That burden makes the path to conviction challenging, even with substantial documentation. Yet, the sequence of events this week demonstrates prosecutorial confidence. The rapid succession of actions from testimony to passport seizure to bond to device surrender suggests they are not merely testing the waters. They are consolidating their evidence, ensuring compliance, and locking down access points. Former federal prosecutors note that this level of coordination and speed typically signals strong confidence in both the evidence and the risk assessment. The volume and nature of evidence, paired with the rare family witness testimony, makes this a uniquely aggressive prosecutorial approach. This isn't just a story about the Trumps. It sets a broader precedent. Anyone who structures financial transactions to avoid reporting thresholds, who moves cash strategically to circumvent federal requirements, is watching this case as a high-profile signal. Small business owners, real estate investors, and cash-heavy businesses may be affected indirectly. The government's enforcement has intensified over the last few years, and this case exemplifies how high-profile examples can influence broader compliance and prosecutorial strategy nationwide. The immediate fallout is tangible. Stocks in Trump-affiliated businesses dropped, bond prices fell, and financial uncertainty spread through markets attuned to political risk. More broadly, the legal landscape may shift in response to this case. Family testimony, previously rare in high-stakes financial cases, could be leveraged more frequently, especially when paired with document-heavy indictments. The devices, scheduled for surrender, represent the next chapter. They may confirm Melania's testimony, provide new evidence, or create avenues for defense strategy. The next few days, status conferences, grand jury sessions, deadlines for device compliance, are critical. This is where the trajectory of the case will become clearer. The legal, financial, and political threads converge into a single narrative. High profile, unprecedented, and fast-moving. Ivanka Trump is restricted, monitored, and facing intense scrutiny. Melania Trump's voluntary cooperation adds an unprecedented dimension. The documents detail structured transactions, offshore entities, wire transfers, and repeated withdrawals below federal thresholds. The defense claims legitimate business purposes and challenges witness credibility. The prosecution is methodical, aggressive, and confident. The devices will either reinforce the narrative or open cracks in it. The bond and passport seizure signal the court's assessment of flight risk and seriousness of the allegations. What makes this particularly extraordinary is the pace. From testimony to enforcement to device seizure, the case has progressed faster than many high-profile federal investigations move in months, if not years. It is a calculated, deliberate, and highly strategic approach. Analysts, legal experts, and market observers all note the implications. This is not just about one individual, one family, or even one business. This is about the precedent being set, the potential influence on future prosecutions, and the interplay between political, familial, and financial considerations. For the public, the story matters because it shows how financial regulations, federal investigations, and family dynamics intersect at the highest levels of power. It demonstrates that high-profile targets are not immune, that family members can become witnesses, and that financial structures, shell companies, offshore accounts, and structured withdrawals are under increasingly meticulous scrutiny. The ripple effect extends beyond Ivanka Trump, potentially influencing enforcement strategies across industries that rely on cash, complex corporate structures, or multi-state operations. As we look forward, the key dates February 11th for device compliance, February 12th for grand jury reconvening, February 13th for the device review deadline will determine the next stage. Defense motions, prosecution responses, and potential new charges are all part of the evolving landscape. The speed, volume, and nature of the evidence suggest this is a unique chapter in federal prosecutions, one that blends financial forensics, family testimony, and strategic legal maneuvering into a single, high-stakes narrative. The broader significance is clear. This case is setting standards, defining precedents, and challenging assumptions about what constitutes knowledge, intent, and compliance in financial dealings, particularly for high-profile public figures. It's a vivid example of how legal strategy, financial auditing, and family dynamics collide in ways that reshape not only individual cases, but potentially the entire framework for prosecuting financial crimes at the federal level. This is where we stand at the end of Part 1. Ivanka Trump's passport is seized, bond set, GPS monitoring enforced, devices ordered, surrendered. Melania Trump's testimony has changed the game. The prosecution's evidence is voluminous, methodical, and corroborated by both financial documentation and witness accounts. The defense is preparing its strategy, challenging credibility, business legitimacy, and intent. High stakes, unprecedented cooperation, rapid developments, and a high-profile target combine to create a story that is just beginning to unfold. In the coming days, we will see whether the devices corroborate the testimony, whether new charges emerge, and how the court navigates this complex intersection of law, family, and finance. For now, the narrative is set, the players identified, and the world watching. This is federal investigation at its most high-profile, precise, and consequential. The next few days will be decisive. Federal court has scheduled a status conference for Wednesday, February 11th. That's when Ivanka's legal team is expected to argue for modifications to the travel restrictions, including the GPS monitoring and limitations on leaving the Southern District of New York. Prosecutors, meanwhile, are preparing additional exhibits, likely to reinforce the timeline of financial transactions, structured withdrawals, and correspondence corroborating Melania's testimony. Then the grand jury reconvenes, Thursday, February 12th, which raises the possibility of additional charges. The documents we've seen may not represent the full indictment. There could be new layers to the case, new targets identified, and more evidence unearthed from the network of shell companies, offshore accounts, and business associates. Every action is a calculated move in a case that is anything but ordinary. The device surrender deadline on Friday, February 13th, is equally critical. Laptops, phones, and cloud storage accounts will be reviewed for deleted messages, encrypted communications, or records that align or conflict with Melania's testimony. If the devices corroborate what she said under oath, the prosecution's case solidifies dramatically. If they contradict her account, the defense gains leverage, potentially undermining the narrative of intent and structured wrongdoing. In federal cases, particularly ones of this magnitude, the devices often serve as the linchpin. It's why prosecutors ordered them after the passport seizure. They already had the witness testimony, and now they need to match it against hard data. It's a precise, deliberate strategy, a calculated layering of evidence that signals confidence from the Department of Justice. The courtroom maneuvers, while procedural, have enormous strategic implications. The partial gag order, which prevents either side from making public statements that could prejudice a jury pool, limits Ivanka's ability to address the media directly or fundraise off the publicity of the case. This constrains her public narrative and prevents the case from being spun as purely political persecution in real time. The defense has pushed back, filing an emergency appeal, but it was denied. The order stands. That means any communication outside the courtroom is controlled, measured, and scrutinized, adding another layer of pressure. For Ivanka, the transition from running international businesses to GPS-monitored travel and restrictions within her own country has been sudden, jarring, and strategically calculated by federal authorities. Legal analysts are unanimous on one point. The combination of Melania's testimony, financial documentation, and device review makes this case unusual for its stage. Former federal prosecutor Ronaldo Marotti emphasizes that passport seizures at this level indicate both confidence in the evidence and seriousness regarding flight risk. Family testimony is rare, but when it happens, it is powerful. Daniel Goldman, former assistant U.S. attorney, highlights how rare it is for a stepchild to testify in such a high-profile investigation. The credibility of such a witness carries weight, especially when corroborated by documents, wire transfers, and financial records. Even opponents of the prosecution acknowledge the extraordinary alignment of evidence, testimony, and timing. The broader implications extend beyond the Trump family. The precedent being set affects anyone engaged in financial structuring, use of shell companies, offshore entities, or attempts to avoid reporting thresholds. Businesses across industries, particularly those operating with cash or complex corporate structures, are watching closely. Accountants, legal advisors, and investors are reviewing histories of transactions, documentation, and compliance practices to understand exposure to similar scrutiny. The IRS has increased structuring enforcement 340% since 2020, and high-profile examples like this signal an aggressive approach nationwide. Whether intentional or not, the message is clear. Financial rules are enforced rigorously, and attempts to circumvent reporting requirements, even through legitimate, seeming business structures, can trigger federal investigations. Financial markets responded immediately to the news. Stocks in Trump-affiliated enterprises dropped 12% on Friday, and Trump Organization bond prices fell 8% by market close. Investors sensitive to political and legal risk are adjusting portfolios, assessing exposure to companies tied to politically prominent individuals, and rebalancing assets accordingly. While these are secondary effects, they demonstrate how legal action against high-profile individuals can create broader financial ripples. Businesses, investors, and markets are now aware that the intersection of law, politics, and family dynamics can produce rapid and unpredictable consequences. The strategic positioning of both sides underscores the stakes. The prosecution has built a voluminous, meticulously documented case, supported by direct testimony and corroborating evidence. The defense has mounted arguments highlighting legitimate business operations, international licensing deals, and potential biases of family witnesses. Questions of intent, credibility, and motive dominate the legal narrative. Every motion, objection, and filing is a maneuver in a high-stakes game where outcomes remain uncertain. Judges' decisions regarding travel restrictions, gag orders, and device surrender timelines signal careful calibration, balancing the rights of the defendant against the integrity of the prosecution. The political and public dimensions cannot be ignored. The case has become a focal point of national attention. Statements released by Ivanka's team frame the prosecution as politically motivated, a narrative that has spread widely on social media and influenced public perception. Prosecutors, constrained by gag orders and courtroom decorum, respond only through filings and legal processes. The tension between public messaging and courtroom strategy adds another layer to the unfolding drama. Media coverage, public opinion, and social media activity all intersect with the legal strategy, influencing perception even as the case proceeds within the strict confines of federal law. Looking forward, the schedule of the next week or two is decisive. February 11th, status conference for defense motions and travel restriction arguments. February 12th, grand jury reconvenes, potential for additional charges. February 13th, device compliance deadline. The next major piece of evidence enters the record. February 16th, expected prosecution response to defense motions. Each date represents a step that will either solidify or challenge the prosecution's case. The compressed timeline reflects urgency, calculated strategy, and the potential for rapid developments. The interplay of family, finance, and federal law makes this case historically significant. Stepchild testimony, structured transactions, shell companies, offshore entities, and high-value assets intersect to form a unique legal scenario. The devices will be scrutinized for compliance, deletions, and communications. The testimony provides context, intent, and motive. Together, these elements make the prosecution's case unusually robust. Yet the defense retains legitimate arguments, challenging intent, credibility, and procedural fairness. This is federal litigation at its most high-profile, complex, and consequential. Ultimately, the story of Ivanka Trump this week is a lesson in the convergence of law, family dynamics, and finance. It demonstrates how rapidly a federal investigation can escalate, how strategic testimony can pivot the narrative, and how high-profile figures must navigate legal, political, and financial pressures simultaneously. Every action from witness testimony to passport seizure, bond imposition, device surrender is calculated, deliberate, and significant. The unfolding events provide insight into how prosecutors structure cases, how defense teams respond, and how both sides maneuver within an intensely scrutinized legal and public environment. In the coming days, we will watch the status conference, device review, grand jury proceedings, and potential new filings. Each action will clarify how strong the prosecution's case is, whether defense arguments hold, and what precedents are being set. The stakes are enormous not just for Ivanka Trump, but for broader legal principles, financial compliance practices, and the way family testimony is treated in federal cases. The convergence of evidence, strategy, and public attention makes this one of the most significant high-profile investigations in recent memory. For now, the narrative is clear. Ivanka Trump is restricted, monitored, and under intense legal scrutiny. Melania Trump's testimony provides unprecedented insight into family dynamics and alleged financial intent. The prosecution's evidence is substantial and corroborated by documents and witness accounts. The defense is actively challenging the case, raising questions of intent, credibility, and legitimacy. Devices will soon be examined, deadlines loom, and additional charges are possible. This case represents an intersection of law, finance, politics, and family in a way rarely seen in modern federal investigations. As developments unfold, we'll continue to monitor, analyze, and break down every filing, motion, and testimony, each document released. Each courtroom action, each strategic decision will inform our understanding of how this investigation progresses. Ivanka Trump's situation is not static. It is dynamic, fluid, and highly consequential. From passport seizure to device surrender, from testimony to bond imposition, the legal chess game is in full motion. Observers, analysts, and the public alike are watching closely, and the coming week will define not only the trajectory of this case but also broader legal, financial, and procedural precedents for years to come.